In this module, we are going to learn about the creation of the Finance Commission, members of Finance Commission, functions of Finance Commission. The need for the Finance Commission was felt by the British government for guiding its finances. The genesis for the modern Finance Commission was laid down during early 1920s, that is, during the colonial rule in India. After independence, provisions were made in the Constitution under Article 280 to make it as a constitutional entity, and accordingly, the first Finance Commission was established in the year 1951. Article 280 of the Constitution reads, "The President shall, within 2 years from the commencement of this Constitution, and thereafter, at the expiration of every 5th year, or at such earlier time as the President considers necessary, by order, constitute a Finance Commission, which shall consist of a chairman and 4 other members to be appointed by the President." In accordance with the provision of the Constitution, the Parliament of India enacted the Finance Commission Miscellaneous Provisions Act 1951 for the constitution of the Finance Commission. As far as the composition of Finance Commission is concerned, the Constitution itself gives the number, that is, it shall consist of a chairperson and 4 other members. With regard to the qualifications of the members of the Finance Commission, it is provided that the chairman shall be selected from among the persons who have had experience in public affairs. As far as the 4 members are concerned, it is provided that they have been or qualified to be appointed as judges of High Court, or have special knowledge of the finances and accounts of the government, or have had wide experience in financial matters and in administration, or have special knowledge. Section 4 of the Act provides that the President shall also satisfy himself that the member will have no such financial or other interest as is likely to affect prejudicially his function as a member of the Commission. The section also empowers the President to ask the member to furnish any such information which is necessary and required by him for performing his duties entrusted under this section. Besides the qualifications, there are also certain disqualifications which are provided so that the members perform their work with integrity and honesty. The disqualifications, according to Section 5 of the Act, are: the member who is to be appointed as member and after being a member of the Commission shall be disqualified if he is found out to be of unsound mind, or he is an undischarged insolvent, or if he has been convicted of an offence involving moral turpitude, or if he has such financial or other interests as is likely to affect prejudicially his functions as members of the Commission. With regard to the term of office and service conditions of the chairman and the members, the Act provides that the chairman and the members are entitled to hold office as specified in presidential order, appointing him as chairman or member of the Commission. The chairman or members are eligible for reappointment, provided they may be later addressed to the President or resign his office. None of the chairmen is offered for reappointment so far. However, some of the members were reappointed as chairperson or members of the subsequent commissions. Further, the members appointed are either whole-time or part-time as specified in the order of the President. With regard to the functions of the Commission, Article 280 envisages that it shall be the duty of the Commission to make recommendations to the President as to, number 1, the distribution between the Union and States of the net proceeds of taxes which are to be or may be divided between them, and the allocation between the states of the respective share of such proceeds. Number 2, the principles which should govern the grants in aid of the revenues of the state out of the Consolidated Fund of India, the measures needed to augment the Consolidated Fund of a state to supplement the resources of the panchayats in the state on the basis of recommendations made by the Finance Commission of the state. The measures needed to augment the Consolidated Fund of a state to supplement the resources of the municipalities in the state on the basis of recommendations made by the Finance Commission of the state. Any other matter referred to the Commission by the President in the interest of sound finance. With regard to the procedures and powers of the Commission, the Act provides that the Commission is endowed with all the powers of a civil court under the Code of Civil Procedure 1908. Specifically, it has powers related to summoning and enforcing the attendance of the witnesses, requiring the production of any document, requisitioning any public record from any court or office. The Commission is also empowered by the Act to require any person to furnish information on such points or matters as in the opinion of the Commission may be useful for or relevant to any matter under the consideration of the Commission. The jurisdiction of powers, attendance of witnesses is whole of the territory of India. With regard to the term of reference of the Finance Commission, the Finance Commission is constituted with specific terms of reference normally decided at the time of its appointment. But additional functions or matters may also be entrusted to it by the President, and that has been followed many times by the government. For example, the term of reference for the 14th Finance Commission, constituted on 2nd January 2013 in para 4 of the notification, states, the Commission shall make recommendation as to the following matters, namely, the distribution between the Union and the States of the net proceeds of the taxes which are to be or may be divided between them under Chapter 1, Part 12 of the Constitution, and the allocation between the states of the respective shares of such proceeds. Second, the principles which should govern the grants in aid of the revenues of the states out of the Consolidated Fund of India, and the sums to be paid to the states which are in the need of assistance by way of grants in aid of their revenues under Article 275 of the Constitution for the purposes other than those specified in provisos to the Clause 1 of that article. And number 3, the measures needed to augment the Consolidated Fund of a state to supplement the resources of the panchayats and municipalities in the state on the basis of the recommendations made by the Finance Commission of the state. With regard to the role and the working of the Finance Commission, its first major role comes in the preparation of federal scheme for finances. The Finance Commission prepares a federal finance scheme basically to serve two broad purposes. Number one, augmenting the state's own limited resources from the surpluses of the Union, and number two, to ensure the transfer of funds in such a manner so as to assist adequately the states with comparatively less capacity to raise resources. The Finance Commission performs the role of recommending distribution of financial resources on the rational and need base so as to ensure equitable development and preventing disparities in the country, and termed it as integrated view of the finance of the Union and the states. The Commission broadly follows the following steps in determining the transfer of funds or devolutions to be made to the states from the divisible pool. In the first step, the Finance Commission determines the size of devolutions based on broad consideration of the needs of the states and available surplus funds with the Union. In the second step, an assessment of the fair costs of revenue receipts and expenditure of the state is considered based on revenue resources of previous year level of taxation and the requirement of expenditure on revenue account. In the third step, a broad assessment of the shortfall in state's revenue resource is undertaken by the Commission. After that, the Commission determines how far this requirement should be covered by the devolution of taxes and grants under Article 275. And lastly, while making recommendations for devolution of financial resources to the states, the Commission addresses the question of determining the size of the devolution on a broad consideration of the needs of the states and available surplus funds with the Union. In making its recommendations, the Commission follows the following principles or considerations. Number one, taxes under Article 269 are levied by the Government of India largely for the sake of uniformity and convenience, and they are therefore distributed between the states on the basis of their origin. Article 270 provides for compulsory sharing of taxes between Union and the states, and their distribution has to be made among all the states in which they are leviable, in conformity with the suitable principles devised for the purpose. Article 272 provides for sharing of Union excise duties, which were to be paid from the Consolidated Fund of India, but the 10th Finance Commission provided for sharing of proceeds of all the Union taxes and duties with states except for the central sales tax, consignment tax, surcharge on central taxes, and earmarked cesses. The first Finance Commission had also suggested that the budgetary needs should be the starting point for determining the assistance required by the states. But the second Finance Commission observed that the needs disclosed should be adjusted with the following considerations, namely, the budget of the states be made comparable by incorporating abnormal, unusual, and non-reusing items of revenue and expenditure. Due allowance for clear cases of failure of the states to maximize tax efforts. States endeavor to secure reasonable economies in expenditure. Lower standards of social service in a state be considered as qualifying condition for special assistance. Special disabilities due to abnormal conditions and beyond state's control required to be suitably compensated. Grants for the advancement of broad purposes of national importance like primary education of the states, which are backward on that count, be given. Therefore, the Commission considered that in transferring resources from the center to the states, the Finance Commission have been largely guided by the consideration that in our vast country, people's need can be effectively attended to only by the agencies close to them and in the functioning of which they are fully involved. Accordingly, the Sixth Finance Commission also recommended the need for ensuring the even development of the different areas within a state, which in the opinion of the Commission can be ensured only through a significant measure of decentralization of powers and resources in favor of local bodies at district, block and village levels. The Seventh Finance Commission also observed that for the devolution of taxpayers rather than grants in aid should be followed, as it helps the states to get the benefits of buoyancy in the tax receipts of the center and of the additional taxes raised by it. In this regard, the Commission viewed that the grants in aid element in the transfer schemes should be, as far as possible, be a residual item, and the attempt should be made to make the bulk of transfer through tax shares. However, the Eighth Finance Commission has raised two objections to the gap-filling approach of center and states. First, this approach encourages the less well-managed states to squander resources, knowing their deficit will be made up by the Finance Commission. And second, a revenue deficit is not a complete indication of the needs of the state. The quantum of physical transfer is assessed on the availability of the resources and expenditure requirements of the center and the states, obviously on the basis of certain principles and norms. After deciding it, the Commission decides the vertical and horizontal devolution of taxes. The Finance Commission have adopted a normative approach, which means the assessment of resources available and expenditure commitments forecast by different government entities is undertaken. The estimate of overall resource envelope available to the general government, which includes gross revenue and receipts of Government of India and the state governments, and the desired roadmap for physical consolidation is undertaken. The 13th Finance Commission has taken the following four principles for the physical transfer to the states. These are: it attempted to ensure symmetry between center and states and applied a normative discipline for both the center and the states. The Commission has accorded equal treatment in the sense that it has not accorded automatic priority to any level of government and concerned with equalization, not equity. In other words, the principle does not guarantee uniformity in public services across India, but addresses the physical requirements of each jurisdiction to enable such uniformity. The public services rendered to the citizens should not only have or address of the concern for uniformity, but also we have a definite level of predictability. It means that the physical transfer to the states should be made in such a way so that the said public services should not be negatively impacted by uncertainties and or vitalities regarding resource flow. There is a complex set of intergovernmental institutional framework in India, and the institutions like Planning Commission, Finance Department, planning boards of different states, state finance commissions, the judiciary and the legislature, in addition to Finance Commission, constitute this kind of arrangement for determining and mobilizing the allocation of public resources. The 13th Finance Commission also sought to maintain the incentive component with the devolution formula. With regard to the principles governing the design of grants, the amounts of grant in aid provided to the states by different finance commissions have been under constitutional obligation of the Union Government as per Articles 273(1) and 275 subclause 1. There are other grants which have been given to the states, and these are grants for reducing disparities in the availability of various administrative and social services across states, grants to meet special financial burdens emerging as a result of peculiar conditions in a certain specific states, grants to provide resources for specific activities considered to be national priorities. Article 280 subclause 3 and Article 275 entrust the duty to the Finance Commission to make recommendation with regard to the principles which should govern the grants in aid and the specific sums to be paid to the states which are assessed to be in need of assistance. The Second Finance Commission recommended the following principles with regard to grants in aid. The eligibility of the states to grants in aid and the amount of such aid should depend upon its fiscal need in a comprehensive sense. The gap between the ordinary revenue of a state and its normal inescapable expenditure should, as far as possible, be met by sharing of taxes. Grants in aid should be largely a residuary form of assistance given in the form of general and unconditional grants. Grants for broad purposes may also be given. While they last, they should be granting aids of revenues, but the states would be under obligation to spend the whole amount in furtherance of the broad purposes indicated. Where those purposes are provided in a comprehensive plan, there will be no scope for such grants. The Sixth Finance Commission proposed a part of the grants in aid under Article 275 of the Constitution is for the purposes of equalization of administrative standards. The Seventh Finance Commission has given consideration to the scope of grants in aid under Article 275 for meeting capital expenditure and observes that it seems unreasonable to hold that the operative part of the article enables Commission to make grants for revenue expenditure only, which provides and enables grants being made of the revenue as well as capital nature. Hence, the Commission can recommend grants for both the purposes. The Seventh Finance Commission laid down the laid down the following principles for grants in aid. Number one, it should be given to enable states to cover up their fiscal gap left after devolution of resource, taxes and duties, to enable them to maintain the levels of existing services. Due consideration is required to be given to the states for its tax efforts. Economy is in expenditure consistent with efficiency and prudent management of public sector enterprises. Grants in aid may be made as correctives to narrow down disparities among states in terms of the availability of administrative and social services. The objection is to extend services to all citizens with certain basic national minimum standards of such services. Grants in aid may also be given to the individual states to enable them to meet special burdens. The objective is to extend services to all the citizens with certain basic national minimum standards of services. Grants in aid may also be given to the individual states to enable them to meet special burdens on their finances because of their peculiar circumstances on matters of national concern. The 13th Finance Commission has also observed that the grants can also be given to the states to reduce disparities in the availability of various administrative and social services across states, allow particular states to meet special financial burdens emerging as a result of their peculiar circumstances, and to provide resources for specific activities considered to be national priorities. It also states that the objectives of extending grants need to be to ensure additionally of resources, that is, the overall result of the grant should be to reduce the deficit in resources to provide public goods, to improve transparency and accountability, and enabling a feedback route in improving policy formulation and implementation, and to assist in better monitoring of expenditure by providing incentives to performance or prescribing conditions for extending grants. As far as the resources to the local bodies is concerned, the Constitution Amendments 73rd and 74th has entrusted the duty to take measures needed to augment the consolidated fund of state to supplement the resources to the panchayats and municipalities in state on the basis of the recommendations made by the Finance Commission of that state. The provisions inserted by amendments had become effective before the 10th Finance Commission finalized its report. Therefore, the Commission is obliged to make recommendations regarding measures to augment the consolidated funds of the states for this purpose, although it was there in their term of reference or not. Thank you.